If you own real estate outside of California, even just a small share, you need to hear this. Many people don't realize that if your out-of-state property is not titled in your trust, your loved ones could face something called ancillary probate. And trust me, it's a mess. In this video, I'll walk you through what you need to know about titling property, avoiding probate in other states, and why this is definitely not a DIY situation. Okay, so it's so important to make sure that all of your properties, both in California and outside of California, are titled in your revocable living trust. Well, if a property isn't in your trust, it could go through probate, which is awful. And if you're a California resident and you own property in another state, that property could go through an ancillary probate, which is even worse. What if you own a fraction of a property and it's titled in joint tenancy with somebody else, like a family member? This often happens if you inherit property from a parent going to you and your siblings. So there's a couple challenges with this. First of all, your portion of the property will go directly to the other siblings upon your death, instead of to whom you might want it to go to, maybe like your spouse or your kids, or anywhere else that you specify in your revocable trust. And then there's the horrible situation that what if the other person dies first and then you die shortly after? Then the property goes through probate, and that's not what you want. Instead, I recommend that you put your partial interest of that property into your trust, and you can specify in your trust where you want that interest to go upon your death. It can still go to your siblings or to your kids or to charities, wherever you choose. Please note that a trust can't hold property in joint tenancy with an individual. So if you put your interest in property that was held in joint tenancy into a trust, you're basically breaking that joint tenancy. And the property is then held in what we call tenants in common. At least this is the way it works in California. So if anyone else also owns fractional interests of this property, they'd need to put their interests into their own trust. Otherwise, their interest could go through probate because it's not going to pass directly to you when they're gone. So you need to coordinate this with the other co-owners of the property.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
So Ellen, you might say, you're pretty stuck on this putting property into trust thing. How do you do this? Is this something that Cookman Law could help us with? Well, let me tell you, estate planning is state specific, and each attorney only understands the rules for their particular state where they happen to be certified. So you should work with an attorney who's barred in the state where the property is held. And by barred, I mean they've passed the bar in that state. At Cookman Law, we only prepare trust transfer deeds for properties located in California. But you should definitely work with an attorney on this. Don't try to do this on your own. This is not DIY. You can mess up property taxes or mess up the chain of title, so you don't have the authority to sell or refinance the property. Or you might mess things up with the insurance policy, so you find out that you're not insured when a horrible event happens at that property. Really, this is worth paying the money for to make sure it's done right. So how do you find an attorney in the state where the property is located? Well, your estate planning attorney in your state might be able to make some references to attorneys in other states. Or there's a website called US Deeds where they can connect you to an attorney in the state where the property is located who can help you prepare a trust transfer deed to transfer that into your revocable trust. Now, another option for investment properties is to create an LLC and transfer your properties into that LLC. This provides more protection for, say, a slip and fall on the property, since your liability is then just limited to the assets that are held in the LLC, not all of your assets in total. And if you create an LLC, you would typically do an assignment of your interest of that LLC into your revocable trust. That's how the LLC avoids probate. So if you live in California, but you own property in a different state, now's the time to make sure that property is titled in your revocable trust. And the same goes for California property. That should obviously be titled in your revocable trust as well. We can help with the deeds for real estate in California, and we can point you in the right direction for out-of-state property, so your family isn't stuck in multiple probate courts. Want to stay out of court and keep your plan airtight? Schedule a consultation with our team today.
If this video is helpful for you, share it to someone else who might benefit from it.